Ipob, assassination attempt on Nnamdi Kanu's life and the revocation of his bail, reasons for Binta Nyako to hands off. The bogus treasonable felony charges preferred against the leader of the Indigenous People of Biafra, Ipob, globally, Mazi Nnamdi Kanu by the Nigerian government, has clearly demonstrated that the presiding judge, Justice Binta Nyako, is biased in her adjudication of justice. The only remedial option available to her professional career and reputation is for her now to totally hands off the case. If Justice Binta Nyako is not playing out the planned game of the Nigerian government, she, in accordance with her professional calling, ought to have instituted an investigation into the circumstances that led to the accused but bailed individual's failed appearance in court after several adjournments. Even the most unintelligent judge in this world should have commonsensically known the right thing to do in the circumstance. Such an accused, supposed to have been strictly placed under security protection of the court, most especially when such enjoys a very clear foreign citizenship. But this is not so to be as far as the Nigerian Federal High Court, presided over by Justice Binta Nyako, is concerned. She has showcased herself as a product of Stone Age Sharia legal system, who is starkly ignorant of both local and international laws. Mazi Nnamdi Kanu, during his bail ruling, made it clear that he is a Jew by ancestry, which the court upheld. That precipitated a demand that a Jewish rabbi be made part of the 3 sureties required for the bail to be granted. The Ipob leader is a Biafran by birth with a clear Biafran birth certificate. He subsequently in life willingly obtained a British citizenship. The Nigerian citizenship was forced on him afterwards when the nation of Biafra was re-annexed by the Nigerian government following the genocidal war levied against Biafrans. That, of course, he pointedly renounced in the year 2015. His Nigerian and British citizenship passports were confiscated by Binta Nyako's Federal High Court in Abuja. From every indication, Mazi Nnamdi Kanu is indisputably a foreign nationale, with a British citizenship, Jewish ancestry, an indigenous Biafran by identity and an Igbo by tribe. He has absolutely nothing to do with Nigeria. Therefore, if the Nigerian government arrested such a foreigner, illegitimately detained and arraigned him in a Nigerian court, on trumped-up charge of committing treasonable felony and subsequently granted him bail under stringent measures, such a foreigner, no matter who, ought to have been given strict security protection by the same court. Justice demands, therefore, that if anything untoward happened to him, such a court would be held accountable for his ordeal, pending his acquittal, with all his traveling documents fully restored. But because Justice Binta Nyako is a product of quota system, half-baked, Sharia law judge, she is stupidly presiding over a court and trying to interpret common laws, oblivious of these glaring realities. She is ignorantly culpable in the assassination attempt on the life of the Ipob leader, her refusal to entertain the details of that murderous military expedition, notwithstanding. It is on record with clear visual and still pictorial evidences that Mazi Nnamdi Kanu was really targeted for assassination in his compound at Afara Ukwu, Ipob in UAE, Abia State by the Nigerian Army on Presidential Directive on 14 September 2014. This was with the complicity of Justice Binta Nyako, just few months after the obnoxious bail conditions were handed down to Mazi Nnamdi Kanu, in her court. His defense team, led by Honorable Barrister Rifani Ejiofor, promptly gave notification to the same court about the murderous raid carried out by the Nigerian Army on the residence of the accused foreign nationale, earlier granted bail. On notification to the court about this development, the defense team was unaware of the whereabouts of their client, as nothing was either seen nor heard about him. 28 innocent Biafran citizens were gruesomely killed in that murderous raid in his father's compound. Yet the biased Justice Binta Nyako downplayed the report presented before her court by both the defense counsel and the sureties. This stemmed from her assumption that their prime target, Mazi Nnamdi Kanu, may have been summarily done away with in the despicable military invasion. His surprise reappearance in the Holy Land of Israel after over a year absence from the scene, Justice Binta Nyako has remained defiant in her objection in allowing Kanu's sureties and lawyers to give detailed explanations before the court on what happened to their client, resulting in his inability to appear in court. This woman, however, displayed her high degree of judicial ignorance, incompetence and stupidity in her crave to satisfy the ungodly yearnings of the evil Nigerian government. The earlier bail granted Mazi Nnamdi Kanu was laughably revoked on the blatant refusal of the court to hear anything that has prevented him from court appearances. There is virtually no other option left for Justice Binta Nyako in this case, as referenced, than to totally hands off. The court has messed up the judicial process as the presiding judge has shamelessly chosen to exercise the powers vested on her to support the persecution of humanity instead of uncompromisingly upholding justice and protecting human rights. Regarding the factual establishment of Mazi Nnamdi Kanu's British citizenship, his Jewish ancestry, his illegal arrest, detention, stringent bail conditions and the assassination attempt on his life, it is incumbent upon the British government, the Jewish state of Israel and of course the entire global community, to query the Nigerian government on the dastardly inhumane treatment meted on their citizen and ancestral brother respectively, which if not satisfactorily responded to, should attract punitive measures. Written by Mazi Nnamdi Kanu. Edited by Peter Oshagwu. For Family Writers.